A very good morning, good afternoon, and good evening to one and all present here from all around the world. Uh, my name is Sweta. I'm part of the managing committee of KFCRI, that is Kovise Foundation Conflict Resolution International. A brief introduction on the institution. KFCRI is based out of Chennai, India. It majorly functions on two parts. First, it is an accreditation body. It provides accreditation in various fields of ADR such as arbitration, mediation, conciliation, negotiation, and even to be a tribunal secretary. Apart from it, KFCRI is also an ADR center. It has its own rules and its own think tanks. We have a process which can be incorporated in various contracts. And if any dispute is to arise out of such contracts, it will be adjudicated by the institution. We are conducting this webinar, this masterclass in association with the Indian Institution of Technical Arbitrators, which was established in the year 2003. In short, IITR provides a single platform to technical arbitrators, financiers, planners, developers, and architects and engineers of all disciplines to form a collective opinion on the subject related to arbitration and project the same for the consideration to appropriate authorities in India and all around the world. So we have with us various luminaries and who have consented to be speakers for this entire 3-day program. And today we have with us Mr. David Primer Thomas and Mr. Damian James. And I would like to invite Mr. Shanmugadev to introduce them as well.
Thank you, Mr. Shwetan. I take the immense pleasure to introduce this stellar panelist. So this whole masterclass is being divided into several days of program, in which this is the first day. And this day will be consisting of two parts. And the part one will be dealing with international arbitration procedure, force majeure, and the Newark Convention, which will be dealt by, this session will be dealt by Mr. David Thomas. And to give him a brief introduction, Mr. David is a barrister at the Union Essex Chambers. He's a globally recognized specialist in the conduct of complex, high-value international commercial litigation and arbitration. And what is more interesting is that he was appointed as the Queen's Counsel in the 2019, only after 8 years at the bar. So having previously practiced as a solicitor at the international law firm, Herbert Smith. So I would request Mr. David to give us some introductory remarks.
Shamuga, thank you very much indeed. Ladies and gentlemen, good afternoon. I can see that we now have, I think, 93 attendees. So I must congratulate you on organizing a very popular webinar, which I hope will be very successful over the next 3 days. As you said, I'm going to talk about issues arising around procedure and the pandemic. Damian, I think, is going to talk later this morning or later this afternoon about experts in relation to delay. Those seem quite distinct issues, topics, but I think, in fact, both in terms of the law and factual matters that are engaged and the procedural issues that are engaged, actually, I think there's going to be quite a bit of overlap between some of the things that we will be talking about. So first of all, taking off the headings that were given very helpfully in the program for this session, what procedural issues does the pandemic pose? The answer may be that it's really quite obvious what procedural issues the pandemic poses. It has brought us all crashing to a halt for the last 8 or 9 months, and it looks like it's going to carry on doing so for a year or so by the time we actually get over everything. So the most obvious effect that the pandemic has had are the restrictions on travel, and the restrictions on travel in relation to both domestic arbitration in India and international arbitration. I saw an article in one of the newspapers in the UK yesterday to the effect that about 1% of the global population was responsible for some enormous proportion of aircraft emissions. And in identifying the 1% who were responsible for all of that travel, the organization who produced the report that made this suggestion said that to be in that 1%, you needed to be flying about 35,000 miles a year, which it put at 3 long-haul flights, or some larger number of domestic flights, short-haul flights in the United States or Europe or within India. And frankly, I was degree of realization that there have been single arbitrations where I have flown more than 35,000 miles in a single year, and in circumstances where I've had more than one arbitration in which I've been doing the same kind of thing. So there's no doubt that procedurally, international arbitration before the pandemic was in some ways addicted to travel. It was one of the principal features of international arbitration. And that had certain effects. One of the things that people observed historically was that international arbitrations tended not to settle. There'd be a request for arbitration. There might be a settlement at the request for arbitration. There might be a settlement at the first procedural hearing. But very often international arbitrations then went all the way through to a final hearing because the parties were never actually in the same place. And that was a function of our addiction to travel. And what we did historically was we traveled for in-person hearings. We traveled for procedural hearings. The first procedural hearing was frequently scheduled for a day or 2 days when everyone would sit down with a draft terms of reference if you're in an ICC arbitration and literally agree it page by page or up on a screen, which I have done in the past. And then the tribunal would want to hear for half an hour or an hour from each of the parties as to an outline of the case, and would then give a procedural timetable on that basis. That day or 2 day hearing could have involved huge amounts of travel to get to London, Stockholm, Geneva, wherever. That has been massively disrupted. Then we'd all go away, we'd all take our procedural timetables, we would all implement them, we do all sorts of things with the IBA rules of evidence, Scott schedules, Redfern schedules, all that kind of thing. And then we'd reassemble for a week or 2 weeks, again in some nice hotel in some nice city for an in-person hearing. Well, in-person hearings have been disrupted by the COVID epidemic. They've been disrupted at the moment by dint of the fact that we literally can't travel. There are places to which I can't travel from the United Kingdom, even if I want to. The same thing applies for the United States, my Australian friends. I have colleagues in Hong Kong and Singapore who have not been able to leave those jurisdictions for months. So there are problems with literally with traveling to in-person hearings. But in fact, we're going to have problems with in-person hearings, I suspect, for a few years more. And this is even with vaccines and the like coming up. And the reason I think we're going to have problems is this. We will, I hope, get to a stage where there is a vaccine and there is sufficient certainty about infection being possibly endemic. But where we will know where we are and so we can hold hearings. But for the next, I think certainly through 2021, we're going to be in the position where if you are in contact with somebody who is infected, who is identified as being infected, then you will immediately be subject to public health restrictions. That's going to have an effect even once travel becomes freer in the next, hopefully the next few months. Because if you think about it, if you put together an in-person hearing, and this is something which tribunals are having to grapple with now in terms of what we order or don't order for parties. If you have an in-person hearing with 3 arbitrators, counsel from both sides, clients from both sides, witnesses, and you suddenly get into, let's say, day 4 of a 2-week hearing, and somebody, maybe one of the transcribers, says, actually, I've just been diagnosed with COVID. That entire 2-week arrangement is disrupted. You can't bring people into that group of people who are having to isolate or deal with themselves, and those people can't go anywhere. So the potential risks, I think, of running in-person hearings are going to be significant for the next year, maybe 2 years, even once travel becomes easier. Quite apart from hearings, I think we face problems with the pandemic in terms of the normal arrangements and meetings that we have in person between counsel, fact witnesses, expert witnesses, arbitrators. In the normal course of things, in a construction arbitration, client would hopefully instruct someone like Damien to look at programming issues. Damien would go to site, he would go to the client's offices, he would examine their documents, he would speak face-to-face to the project manager for a couple of days. Then, some point down the line, in the normal course of things, we would arrange a meeting where I would travel along, meet the client, meet with Damien, meet with the project manager, and we'd spend a few days sitting, talking what happened about the project, what happened to the program, how were things disrupted. And in that way, we would formulate the case and start to develop things. Witness statements are commonly, have historically commonly been drafted by the documents being fleeced out, taken out where relevant, given to the witnesses, and the witnesses talked through what their evidence can be so that their witness statement can quite properly be written. All of those things involve face-to-face procedure. All of those things are having to change. All of that in-person engagement, which has been central to international arbitration, is being disrupted and will be for, I think, some time to come. It will also affect, for example, how counsel and expert witnesses are supported. Historically, expert witnesses and counsel would, or lawyer teams would go into a client, and depending on where the project was, people would happily fly into a project in the Middle East, say, fly in, do the work, fly out. Some places are going to still continue to have restrictions on flying teams of people in. If I was to ask Damien now, could Damien please go into Oman to do a job, kind of job that Damien would have done without batting an eyelid, I suspect, a year or so ago? The short answer would be that Damien literally would not be allowed to fly with a team into Oman now or for the foreseeable future. It's also going to affect arbitrators and the way arbitrators work together. It doesn't reveal anything to say that arbitrators work in a variety of manners, partly with draft awards and exchanging notes, but partly by getting to a stage in terms of deliberations and the decision when we finally, or when we meet together for a day or 2 days and work everything out. That is being interrupted as well. So undoubtedly, I think the pandemic has had an effect on the traditional way in which we have practiced commercial arbitration. And I'll come back to this later in this talk. It will continue to do so for, I think, another year to 2 years at least, even as we introduce a vaccine, or even as a vaccine is introduced and put through the population. So you might say, well, that looks a bit like external events, that looks a bit like force majeure. And I made a slightly tongue-in-cheek, slightly throwaway remark a month or so ago that the New York Convention doesn't deal with force majeure. But there is a serious element to that. We have all thought of force majeure in terms of what happened in the pandemic, what happened back in April, May, June, as sites demobilized, as fabrication work ceased, or it was interrupted or suspended. The sort of things that I suspect will dominate Damien's practice for some time to come, analyzing the effects of that. And indeed, one of the interesting issues which he and I have discussed already to an extent is the way in which force majeure events will have had an effect back in March, April, May, but in fact those same events, insofar as they happen now, may not qualify contractors for extensions of time under force majeure provisions, because there will be different issues about foreseeability and the ability to adapt. But that's force majeure from a substantive law perspective. What my tongue-in-cheek comment was about was whether or not the New York Convention dealt with force majeure in an arbitration. And the short answer is I don't think it does. I don't think you can plead or assert force majeure operating on an arbitration in the way that I discussed at the start of this talk. I don't think you can say, look, we had an arbitration, but the pandemic came along and it did various things to the procedure that we faced. And so where does that take us? And it's for this reason. If you look at the New York Convention, it applies, as you will all be familiar, to the recognition and enforcement of awards, but its starting point is also, in fact, the recognition and enforcement of arbitration agreements. Article 2.3 of the New York Convention provides court of a contracting state, when seized of an action in a matter in respect of which the parties have made an agreement within the meaning of this article, and that's an agreement in writing, the likes, shall, at the request of one of the parties, refer the parties to arbitration unless it finds that the said agreement is null and void, inoperative, or incapable of being performed. Now, that is as close as the New York Convention gets to a force majeure provision, that arbitration clauses are to be, parties are to be referred to arbitration unless the arbitration agreement is inoperative or incapable of being performed. You can sort of see a party trying to say, well, we have an arbitration agreement, but it's incapable of being performed because, see all the stuff that I said 5 minutes ago, we can't get together, we can't meet, we can't have in-person hearings. And at the start of the pandemic, parties were beginning to wonder, people were beginning to wonder whether that was an issue that arbitration was facing. And just before we turn to the solutions that have been adopted, which I think mean that, in fact, it's wrong to say that arbitration agreements are incapable of being performed. The enforcement side of arbitration is Article 5 of the New York Convention. And there, really, a party is going to rely on the idea that the party, Article 5(1)(b), the party against whom the award is invoked was otherwise unable to present his case, slightly sexist language in the New York Convention from the 1950s, was unable to present his case, or 5(1)d, the arbitral procedure was not in accordance with the agreement of the parties. Failing such agreement was not in accordance with the law of the country where the arbitration took place. So it seems to me, from a New York Convention perspective, that there is certainly no loosening of requirements that you can identify based on the New York Convention in relation to arbitration procedure. It doesn't say procedure may be modified. And if you think about the effect of force majeure, effectively force majeure excuses non-performance of a contract. the position in relation to the New York Convention, it seems to me, is that if a party is truly arguing that in fact the arbitration agreement is incapable of being performed, or if the party is saying that it's unable to present its case, or the arbitration procedure was not in accordance with the agreement of the parties, well, the consequence of that under the New York Convention is there's no requirement on the national court to refer the parties to arbitration under Article 2, or it would be a ground to resist enforcement of an award under Article 5. So it's not a force majeure-like provision that in some way relaxes performance of an agreement, but certainly in terms of construction contract, doesn't bring it crashing to a halt. It will suspend performance for a period of time and may then lead to termination. The consequence, if issues arise under the New York Convention, really are that you end up without an arbitration. So, how are the different institutions approaching the issue, and what solutions are available to the challenges ahead? Well, I think the short answer is that in contrast to what people were saying back in March and April, that there may be huge problems with arbitration. In fact, the solutions that have been identified are that, notwithstanding COVID, notwithstanding the pandemic, arbitration can continue. Arbitration can continue. Arbitrations can continue to be decided. Hearings can be held. Awards can be published, and awards can be enforced. So that in fact, a party seeking to rely on Article 2 of the New York Convention, the arbitration agreement is incapable of being performed, I think would be met with the answer, and is being met with the answer, no, we can perfectly find a way through this. And similarly, certainly in the circumstances where there are institutional arbitrations, and in most national laws, parties are really not succeeding in arguing that something to do with the pandemic, in particular, the inability to hold in-person hearings, means that that the arbitration procedure isn't in accordance with the agreement of the parties. So you can see in the solutions that have been adopted, and they've generally been adopted by certainly the large arbitration institutions, and they've been permitted by the courts of the major arbitration seats. The first is remote working and remote hearings. The institutions have simply gone to remote working. The ICC and LCIA courts meet remotely. The ICC, LCIA, SEAC are receiving requests for arbitration electronically, and are transmitting awards electronically rather than using hard copies. The LCIA is now very clear that it will receive electronic copies of awards. It will circulate awards electronically. If hard copies are needed, then the LCIA will make arrangements to get them in, circulate them. But I suspect that a number of LCIA arbitrations will probably go through and finish with awards published. And in fact, nobody will end up with a hard copy award, and nobody will worry. And I certainly think, given the approach that's been taken by the courts in England, that somebody who popped up and said, well, hang on, I don't think that actually this is an enforceable award because it was only ever circulated electronically. I think that the approach that the English courts have been taking to the pandemic would mean that a party trying to resist enforcement on those grounds would meet very short shrift. The institutions have supported remote hearings. That's been by their conduct, moving online themselves, and by express guidance. The LCIA held a very, very good round table by Zoom, I think it was by Zoom, in May 2020, at which what was discussed was not, could we hold hearings electronically or remotely? It was, how would we do it? What were the practicalities? What were the issues in terms of hearing witnesses? What were the issues in terms of security? And certainly that is similarly the case of many of the commercial courts. We have undoubtedly in England and Wales had problems with the criminal courts. And I think there may be issues in terms of running the criminal courts remotely for two reasons. First of all, when the individual is accused of a criminal offence, there is still some concern, particularly if issues of personal liberty are concerned, with dealing with that remotely rather than dealing with that in person. And secondly, many criminal courts don't really have, or many criminal parties don't necessarily have access to the sort of technology that we're using this morning, so as to conduct hearings remotely. But undoubtedly in commercial cases, which we're dealing with in terms of commercial arbitration, the sort of technology that we're dealing with this morning is widespread. We may have access to different qualities of technology. I'm sitting here at the moment in front of 3 screens and an iPad. I'm not using them all at the same time, but I have access to that kind of technology. But certainly the idea that hearings can be held remotely isn't remarkable. And as I say, the English courts for commercial work has moved to, very readily moved to hearing cases remotely. The biggest issue I've had is appeared in the Chancery Division a week or so ago, and that was using not using Zoom. I've been using Zoom. That was in fact using Skype for Business, which the English courts have been using. But certainly somebody who appeared in front of the English courts, the Singapore courts, suspect some of the Indian courts, and said, look, I couldn't present my case because actually I was asked to do so remotely. I know some Indian courts haven't gone remotely. I think that the High Court in Delhi has started using remote hearings. And so you would get very short shrift there in terms of saying, I couldn't present my case because the answer would be, well, hang on, you could have presented your case remotely before this court. So why couldn't you do so in front of an arbitrator? Some people worry about hearing witnesses remotely. And I think this will be something which we will go back to doing. I think that there will be attractions to going back to final hearings in person if we can. That's partly because the interaction between the tribunal, counsel and witnesses is better, I think, in person than it is remotely. But it's perfectly satisfactory when done remotely. And I think that is one of the things that the courts and arbitrators have found, possibly to their surprise, that in fact you can hear a witness on quite complex evidence remotely, and tribunals are making a perfectly good job of assessing that evidence. So the whole question of advocacy, hearing witnesses, those sorts of things, and administrative matters have been dealt with, and have been dealt with so satisfactorily that I think now we're getting to the stage where a party seeking to resist enforcement of an award, certainly in one of the major centers for enforcement, New York, London, Paris, Singapore, would meet very short shrift if they tried to rely on the fact that the award followed a remote hearing. The solutions to the pandemic in terms of international arbitration have generated solutions and approaches, some of which I think we will leave behind once the pandemic is away. Certainly we will, in terms of preparing cases, it is easier to prepare a case in person than it is to prepare a case remotely. Although a lot of preliminary work, I think, will be done much more effectively remotely, with a face-to-face hearing off the back of that. Preliminary hearings, which I mentioned at the start of this call, the 1 day, 2 day preliminary meeting to settle terms of reference, do the timetable, I suspect may be a thing of the past. I think that General Counsel, when asked for to budget for an arbitration, the idea of actually flying the tribunal counsel, senior individuals from the clients to somewhere for a 1 day or 2 day procedural hearing, I think may disappear. Because frankly, General Counsel, I think, will take the view that during the pandemic, we have been perfectly able to set up the timetable, to understand a case, to manage a case remotely, and that's been really a very, very effective solution, and one that they won't want to lose. I think, however, that we will look to a very great extent, certainly for longer and heavier hearings, and most construction arbitrations will give you that longer, heavier hearing. For longer, heavier hearings, I think we will move back probably to hearing witnesses at witness hearings in person. And there are a few reasons for that. I've touched on it, first of all, in terms of dealing with witnesses. Where a witness is being impeached, I think it may be easier or better for that to be done actually in person than for a witness to be impeached if it is suggested that they're lying or seeking to mislead the tribunal, than to do so over this kind of medium. Also, I think that dealing with expert testimony will be is easier, in fact, in person than it is over this sort of technology. One of the things that I presently haven't done, although I suspect I have a hearing coming up where I suspect I will do it fairly soon, is witness conferencing over something like Zoom. And that's a dynamic, that's a tool of witness conferencing, where in fact part of the tool is the dynamic between the witnesses. That over Zoom is going to be very difficult. And finally, I think some people will suggest that it may be possible, and what we may see is a move towards hybrid hearings with some witnesses and some parties in person and some on Zoom or a similar technology. My own view is actually skepticism in relation to that. Within my own chambers, we've noticed that actually if we have hybrid meetings in chambers, there is a different dynamic between the people who are in the room and the people who are on screen. And I suspect that parties will resist hybrid hearings for that reason, because the dynamic will be different. The effect of this for us as practitioners will be we will get used to using this technology, and it will all be available for us to use. I have not done a paper arbitration for I think 2 years. The arbitrations that I have been doing, the bundles, the pleadings, the witness statements, but the underlying documents as well, have all moved electronically. That was happening anyway, but what's happened in 2020 has accelerated that. In terms of my own chambers, we now have much better infrastructure in place for dealing with electronic bundles. All of those things have moved on. We have much better infrastructure in terms of hearings as well. At the moment, I'm doing this from home, but I also have infrastructure to do this kind of thing or hearings from chambers. So, to summarize, undoubtedly the pandemic has had a profound effect on arbitration, and our addiction to international travel, which probably marks us out as one of the industries that should be on the global naughty step in any event. It has fast forwarded, I suspect, our practice and procedure by a good 10 years in the space of 1 year. The New York Convention doesn't relax its requirements in circumstances like these. A party that suggests that something has happened that means that the arbitration agreement is incapable of being performed or was not performed as agreed would in fact be blowing up the entire arbitration rather than in some way arguing for a relaxation of procedure. But in my view, what has been demonstrated is that the alternative procedures that we have put in place and that I think will stay in place will in fact fall to be analysed simply as being part of arbitration practice for the past year and going forwards. Shanmuga, thank you very much. I think I said I'd take Q&As, unless in fact it's easier if we move to Damien and we take Q&A together, or I'm in your hands.
Definitely. So thank you. This was really informative, and thank you for making it more interesting, sir. So I think most of the questions we have already discussed and they are repetitive. So I'll just compile into one or two questions. There's a question from Mr. Dineshwar Gaur and Mr. Rajesh Krishna. I'll just compose it into one question. The question is that in case none of the parties is responsible for the delay, who would ultimately bear the cost of such delay? And he's also asking for an example of such COVID-19 scenario. And Mr. Rajesh Krishna's question was more about applicability of the force majeure. This is the question, sir.
I think the question, certainly Dineshwar Gaur's question, is really related to, it seems to me, to construction contracts and the sort of thing that Damien will be moving on to. I think Rajesh Hazra's question, yeah, I think that actually, as I said, my reference to force majeure under the New York Convention was a slightly sort of tongue-in-cheek throwaway remark. I don't think you can assert that an arbitration has been affected by force majeure, is the very short answer. The arbitration procedure itself, without sort of taking Damien's observation, really Dineshwar's question goes to what I teach when I teach my LLM students. Construction contracts aren't about good guys and bad guys. They are occasionally, but that's just sent to spice up our careers. Construction contracts are about risk and the allocation of risk. So in relation to any construction contract, you can say one or other party will bear the risk. So in COVID-19, the question is not who's responsible for the delay. I'm pretty sure I've not seen yet anyone alleging that an employer was actually responsible for the pandemic, although you can imagine an interesting arbitration between some biotechnology company and a construction company, but that's the realms of fantasy. But no, if you are dealing with a pandemic, the question is who bears the risk of what the pandemic has done. Has the pandemic forced the suspension of work on site? Has the pandemic forced the suspension of fabrication? All those things. Once you identify that, who bears the risk of that happening? And one way or another, by either the use of express words, or if there aren't express words, then that's where Damien and I really start to earn our money, is identifying where that risk falls. It's not a question of somebody actually being responsible or at fault.
Thank you so much, sir. So before going to the next speaker, Mr. Damien, and giving about an introduction, I would like to thank a few of the resource persons present here. So Mr.V.Inbavijayan, sir, who is the project advisor, thank you for joining. And we do have Mr. Anishwarya, who is our background member and is one of the resource person of KFCRI. So thank you. And we have our tomorrow's speaker, Ms. Chanton. So thank you, ma'am, for joining. And we do have our other managing committee members, Mr. Shweta and Shahrukh. So a brief introduction about Mr. Damien James. So Mr. Damien James will be dealing with the part 2 of the today's session, that is delay and the role of the expert. So Mr. Damien James is a leading expert in the area of quantum delay disruption and cost evaluation. And he has been appointed as advocate in arbitration and as expert in adjudications. So what is more interesting is that he's widely experienced in engineering and construction claims and dispute resolution, and has particular expertise in the preparation of detailed claims to recover the claimed entitlements. So thank you, sir. The dice is yours.
Thank you, Shanmunga. Hopefully you can all hear me. And good afternoon to everybody, and thank you very much to the Foundation for allowing this masterclass, and to allow it over the next 3 days is of great importance to all the attendees, and it's a great opportunity to have some great speakers. And obviously we've heard from David this morning, who's been very eloquent in his elaboration on his subject matter. Yes, I do work as a delay and quantum expert, and I practice in international construction disputes mainly. I also sit as an arbitrator, which I prefer to do as part of a tribunal, and I have a particular focus on technical aspects of construction disputes, which undoubtedly involves delay and quantum in construction matters. And obviously, this year has been a most unusual year in respect of construction projects, and we've seen a major shift, seismic shift really, due to the coronavirus and the effects it's had on existing projects, future projects, and projects which have almost suspended their works and restarted due to government regulations. And with that, there's seen the role of the expert in assessing time and money, and the very real situation of causation, foreseeability, and effect, which are the major issues that experts are engaged in. And in being engaged in such, it's obviously their position to provide such analysis to arbitral tribunals, and to do so with impartiality and with regard to the actual facts. So the role of the expert has changed as well this year, and as David has suggested, the days of rushing out to projects and spending 2-3 weeks there and being engaged in interlocutories with your fellow experts in hotels and city centres in faraway countries has changed, and this year most of my work has been done virtually online, and that's from an expert point of view and from an arbitration point of view, and virtual hearings seem to be here, and they seem to be here for good at the moment, and they can be of great benefit to us all. Obviously, the first part of my presentation really talks to the importance of the independent expert, and I think it's important to delineate that in the period of the COVID situation and the foreseeability, and for people to understand the role of the experts is an impartial role. And in simple terms, we talk of 2 types of witnesses. We talk to witnesses of fact who may give evidence but don't normally give an opinion, whereas the expert witness will give opinion evidence, and which is within their expertise, and in addition to evidence of the facts. And I think that's an important distinction for people to understand. Expert witnesses such as myself, we can be anybody who has a knowledge or experience of a particular field, or to some extent in a discipline, but our experience and our knowledge is beyond that of the layperson. So, for example, my experience sets back to being a contractor's quantity surveyor some 30 years ago. So it's rendered me with suitable experiences in contracting disputes. I think the recognition for experts, and we may have 1 or 2 on the call today as well, is that, you know, the duty is to the court or the tribunal, and it's to provide what is an impartial opinion on particular matters, or particular aspects of a matter within the expertise which are in dispute. And And this differs very much from an expert advisor who often sits alongside clients who does not have an overriding duty to the court, but to the party who instructs them. The importance of the expert witness is not to be an expert advisor and not to advocate a party's case for them, but it's to assist in the formulation and preparation for the tribunal's understanding. And it's probably never been more important. And David is an arbitrator, and Johan Bayers, who joins us tomorrow, or sorry, on Friday, and Chantal Humphreys, who both sit as arbitrators. In the virtual world, the eloquence and the testimony and the report writing skills of experts is probably more important now that they can eruditely extinguish their role as an impartial arbitrator. And in doing so, they must provide an independent expert report in the areas of expertise, and that's essential to it. The reports are required, and obviously we're going to see reports issued virtually and online and through a soft portal, as opposed to the hard copies and the bundles of documents we've normally seen ourselves within arbitrations. And that's in preparation for the virtual hearing. And in that virtual hearing, we would expect the expert to be challenged or to be questioned or to explain and to particularize elements of the evidence that they have given or the opinion that they have given. And in doing so, obviously they provide their report to the other party's expert. And in doing so, that allows for the process on a virtual basis for experts to engage with each other. And the difficulty with that is that obviously I'm engaging with certain experts now in certain disputes that I'm working within. And the biggest issue I think I have is probably time zones. That I've been on a call this week, which was 10 o'clock in the morning in the UK, but was 7 o'clock in the evening in the APAC region. And obviously to get the traction and to get the involvement, the engagement together, it is difficult. The way we've decided to do such is by agreement to share the responsibility in terms of time zones. But similarly for matters in China, and I know that Anish Wadia has just been working on some of the moot arbitrations that are proceeding in Beijing at the moment. Those timings have been at 2:30 in the morning English time. So there has to be a degree of latitude between the experts in order to extinguish this responsibility to the arbitration tribunal. And the role fundamentally is to provide truthful, impartial and independent opinions. And to do so, we don't need hired guns, we don't need parties and experts, we need experts who are impartial and do not advocate cases. Similarly, we don't want experts, definitely in this particular time, not to be providing opinion beyond their specific area of expertise, and that specific area of expertise
I think we've lost Mr. Damien right now. I think he'll join back in a couple of minutes. We'll just wait for it.
While we're waiting for Damien, if we've lost him, I noticed some of the other questions that have arisen. We might usefully. Damien looks like he's coming back.
Yeah, sorry, I don't know whether that was just me or that was everybody, so I do apologise. And yes, just continuing with the expert witness, obviously the expert witness not there to act as a negotiator. So the very real prospect of being in the room and the environment of conducting expert meetings has now changed into this virtual environment. And with that, experts must apply some real care and attention to how they execute their role and how they deliver the instructions that their client has asked them for. In the UK, we sort of, or definitely in England and Wales, we look at three types of experts. We look at the party appointed expert, which is those experts that are appointed and instructed by the parties in the dispute. We also look at the single joint expert, which may be of assistance as we move forward. And then we also look as the expert advisor, which, as I've said, is the shadow expert and works on the instruction of the parties. Expert witnesses are required when it's necessary to have opinion evidence to assist in the resolution of a dispute. And the opinion at sometimes may lead to early resolution of the dispute. Obviously, what we're seeing now in the COVID time is that the impact of the pandemic, it still continues for employers and contractors, and it still continues for subcontractors and suppliers. And we are still seeing new impacts. And without the effect, we can all understand what the causation is, but obviously we're seeing new effects that we can't always foresee and maybe slightly remote from what we anticipated at the start of the project. And it's probably likely that in the future phases of our recovery from the COVID situation, there will be new impacts that we're not aware of at this point in time. The difficulty with this is obviously it continues to expose the construction industry, and I talk to the construction industry because it's my area of expertise, to uncertainty in terms of cost recovery. And that applies for employers, contractors, where liquidity margins and solvency are actually being stretched to the limits. And the point that we talk about again is the allocation of risk. And we often talk of the employer risk, contractors risk, and where it sits. And some people will say that risk obviously employs the employer because they push as much as they possibly can onto the contractor. But there are genuine risks here that we don't know what the effects are at this point in time. And we talk to the good guys and we talk to the bad guys, and it's often the contractor being the bad guy because he's performing woefully on a project, or it's often that the employer is the bad guy because the employer is not recognising the issues that the contractor ought to be entitled to recover in respect of time and money. So we're always going to talk to who owns the risk, and COVID situation is not going to differ from that. In the first wave of COVID, maybe it was a lot clearer where the risk actually sat in respect of the contracts that were written at the time. But in the period since the COVID effects has continued, there has been new contracts and there have been new tenders, and the allocation of risk in those new tenders and contractors has been more accurately defined to favour maybe the employer to some extent. And with that, we have contractors who now find themselves exposed to greater risks, not only in terms of how they manage the works and how they attend to specifics on the project, but they have bigger risks now in respect to the productivity ratios that they previously expected to be applicable to the projects they work in. And with contracts being signed up for the next 2 years, 3 years, 5 years, we don't know when that risk is. It's almost a sort of sleeping giant or a sleeping risk at the moment. There will be further issues that come to the fore, and there will be great challenges for employers and contractors in dealing with these from the foreseeability issues. And when we talk to foreseeability, I mean, obviously apologies to the lawyers amongst us, quite eminent ones as well, especially the one that spoke before me, but lawyers approach claims with the knowledge that it's not simply enough to allege that A owes B a duty of care. The approach is to establish and determine the scope of that duty. This determination takes us into an aspect of law that is variable, and express terms may provide for such, but also the implied terms that provide for a contractual duty need to be considered. And we'll have seen that in the period after COVID, after the first wave of the COVID pandemic, the actual express terms have been changed and become more varied and more risk-bearing for various of the parties. However, they don't deal with every aspect of the impact that sits there. So this question of foreseeability still arises. And for construction disputes, this is the biggest area that we need to consider in approaching an analysis as an expert in respect of delay and time. And in broad terms, the essential ingredients for the analysis is the evidence of the causation. Well, undoubtedly, the evidence of the causation is the pandemic and the COVID-19 outbreak and how it has affected different countries. And yes, we talk to force majeure and prevention and frustration in different terms under the contract, but what we need is, in broad enough terms, there must be a sufficient connection between the breach that we allege and the loss in order to recover damages for the breach of contract. And when it's force majeure, we may have further difficulties because we may only be looking at recovering time alone. But the damages that we we do suffer caused by the breach of the contract. That is the causation, and that is clear where we are at the moment. The damage suffered by reason of an intervening act, which is whether it's by a third party or in this case, the pandemic, which the defendant could not reasonably foresee, will not be recoverable in certain instances. So as we move forward into phase 2, phase 3, we've seen sites suspended, we've seen sites reopened, we've seen sites terminated because the very real situation in respect of solvency has become a problem for employers. We've seen contractors go into liquidation. We've seen a whole number of them across the UK. We've seen them in the Middle East of late. And the foreseeability may not deal with that because the issue of solvency separates itself from that. And the anxiety and the stresses of the COVID situation has resulted in many contractors finding themselves in a very much irrevocable position. And as we move forward, the test for foreseeability is no doubt at the time when the contract was formed and not at the time of the breach. But now we have new contracts which have new tests of foreseeability. And we need to consider those when we look at foreseeability, we look at causation, we look at the resultant effects. And for experts as myself, it's very difficult now on the foreseeability basis to actually say that that element wasn't foreseeable or that element was foreseeable, because almost everything now attaches itself to the pandemic and to the COVID-19 outbreak. COVID-19 seems to be singularly responsible for all sorts of causation and all sorts of effect on the project. And it's unfortunate that we almost sort of venture into a situation where damages arise by actions and there may be no liability because there may be a remoteness as well. And that's something that has to be challenged as we come through into this next phase. We've seen that with many claims in terms of termination and prolongation on COVID-related projects, that there's been a whole number of types of claims. I've been asked to provide claims for loss and expense. I've been asked to provide claims for loss of opportunity, and I've been asked to provide claims in respect to reputational losses which have followed from termination. Very, very difficult approach to have to take in this situation. I mean, ordinarily, a contractor can claim that but for an event, the delay in the project, the issue in the project, the workforce that he maintains or his head office would have had the opportunity of being employed on other contracts. Well, is that correct now? Is the very real effect of going from one project to the next project a reality, or are projects being delayed so there are no claims for head office overheads, there are no claims for loss of opportunity? The test of remoteness is something that will be debated further, and it's very difficult in terms of delay and quantum analysis to actually know which elements of these to support. Because the first principle is that the contractor would always be able to prove that he had other work available but for the delay. Well, the other work that may be available may be in the second and third phases of the COVID outbreak, and in very real terms may be more expensive for him. It may be work that he wouldn't have won, maybe work that he didn't want actually to complete. And you know, I've always had great difficulties in dealing with the issue of secure, even in a time when the market is buoyant. And I've seen contractors rely on average success rates of their tenders in terms of how many they bid for and how many elements that they work for. They win as a result of that. Remoteness in damage, you know, we could debate this with the lawyers amongst us. It talks to precision, it talks to justification, and it talks to whether valuation can be made at all. And that's an issue we face now going into the second, third. How many of these items or these impacts were foreseeable? How many of them ought to be foreseeable? How many of them are so remote from the COVID situation that they weren't foreseeable? But we may be able to look at these on the balance of probabilities, and that's a separate debate. But in any such case, causation, it's prudent to put forward the evidence with causes through undoubtedly the records that you have for the project and to establish the genuine intention of the issues before the ultimate contest on the contractual eligibility that will follow. And the eligibility morphs into the legal aspect, and it's for advocates and barristers such as David, Johan and Chantel to advocate on a party's behalf in terms of those specific merits. I mean, the entitlement can be addressed in terms of delay and quantum, but there's always going to be a requirement for guidance in respect to foreseeability and remoteness and the ultimate nexus between the two events. We talk often in terms of causation and foreseeability, and we always use the example of adverse physical conditions. And we always talk to the fact that adverse physical conditions may be difficult for the engineer to determine because it's for the engineer to assess, and it may be unreasonable for every single party to inspect the geological conditions of a site, etc. Whereas now the conditions that we're dealing with are the conditions from the COVID outbreak, and we may be dealing with conditions from COVID outbreak number 1, which is 28th of March back in the UK. It may be the COVID outbreak number 2, which is after the lockdowns that each different jurisdiction has taken before recovering into the workplace, and new permutations and new issues have manifest themselves on the construction project. The separate issue we have that is the form of contract in that respect, and it's almost a subjective standard, because under a FIDIC contract we would find the engineer determining and deciding what the relief was for the contractor making a claim, and this does not eradicate the foreseeability. So let's just take to a next step, and let's take to the arbitrations that may manifest themselves in some time, or maybe actually beginning to commence in respect of disputes from the first phase. The test of entitlement is still foreseeability, that which is foreseeable by an experienced tenderer. Now, what does that experienced tenderer mean in this situation? Well, we've only had a short experience of tendering during the pandemic situation. So whereas differentiating what was foreseeable and what's naturally foreseeable, it may be the case that tenderers don't know what's foreseeable anymore, and they don't know the reality. Yes, we've got more refined at it, but there are further issues that are coming into existence as we move through the COVID and the post-COVID situation. The most important thing for the employer is to give the contractor as much opportunity as possible to consider all of these risks. And those are practical considerations of the jurisdiction in terms of the regulations and the health and safety requirements, practical jurisdictions in terms of the territory of work and the need for various provisions and their various safeguards. Again, returning to the FIDIC contract, then obviously we see that the engineer becomes responsible for extinguishing a lot of those conditions on behalf of the employer, and we almost return again to that subjective standard of what the engineer actually determines as being correct in terms of foreseeability. The foreseeability test must meet a standard, and then risk ought not to be transferred to the contractor. So if something is, in that situation, we're talking to something which is foreseeable, does it transfer to the contractor? If it's not foreseeable or it doesn't meet the standard, then it can't be transferred. The alternative contention may be that a risk remains with the employer because the employer has the best opportunity to control or avoid the risk through the whole pre-tender situation and has the best knowledge of the decision to build a specific contract. And then when we talk to the issues of losses and damages, yes, we have some good case law. We have good case law through England and Wales. We have good case law in South Africa in respect of claims and the causation that follows from there. And we can talk to head office overhead claims, and we can refer to Walter Lillian Mackay, which talks to the use of formulas as assisting without drifting too far into the area of remoteness. But there will be new tests for foreseeability and new tests for remoteness and new case law, which is going to be provided to us over the next coming years. And unfortunately, we're not seeing those at the moment. So we're very much based on the reality of the argument of the legal profession, their ability to apply the law to the foreseeability, and their ability to assist in terms of how the causation and the resulting effects can be demonstrated from an entitlements and a merits point of view. The big issue now is obviously parties who enter into contracts will be attesting to and signing to specific clauses, and they generally deal with the risk issues, they generally deal with the variations, and they deal with changes in scope. The big challenge now is what consideration is being given to these and what is being contemplated in respect of what the contracts expressly forbid, irrespective of whether they are reasonably foreseeable or not. So there are other ways of managing the process which allow the foreseeability test to be made. But this might suggest that certain valuation is remote from the facts. So contractors are going to be constantly challenged with first justification and thereafter evaluation in respect to the COVID situation. And this will continue and continue for the next 2, 3, 4, 5, 6 years. The challenge of doing so under a virtual environment has its own difficulties because genuine engagement between parties in terms of debate and discussion, which is what experts will tend to do on a without prejudice basis, might not be as easy to understand without necessarily going to site, without necessarily appreciating the actual remoteness of certain mega projects. It might be difficult not to appreciate when you don't understand the jurisdiction. Yes, you understand from the knowledge that you can gain from it, but sometimes being in the area and the practicality of how projects are conducted, how 14,000 labour resources are brought to site and biometric tested every single day, when there's hand sanitizer, where there's a requirement for masks, etc. All new items in terms of causation, but then how is that assessed in terms of productivity? Is it a straightforward idling time? Is it a straightforward lack of productivity? Legal disputes involving foreseeability in the construction industry are inevitable. They've always been inevitable, and they are even more inevitable now. It may be the case that the parties can avoid the complications and conflicts that we've talked about in this discussion by refining the terms of their contract. And yet again, you know, before parties draw up, sign and execute contracts, everyone should become directly familiar with the entire project and the entire conditions that permeate through it due to the COVID restrictions and the future COVID restrictions. That should be reflected in the intended schedule. Perhaps we should be dealing with project float in a different way. Perhaps we should be introducing restrictions and constraints in terms of programs that allow a scenario that an item in respect of causation can be tested. And if it's tested and it results in a situation which is longer than that was programmed, then the parties may agree to resolve that issue and to extend the period that's there. But that will only happen by engagement and by both parties identifying and dealing with the risks. Obviously, the major issue for contractors is they don't want to find themselves in a situation of making claims to recover their money. And the major issue for employers is that they don't want to continue in projects where they will be subsequently provided with a claim which is almost for double the amount of the contract. So the whole process in terms of change, development, is a difficult process, is a difficult aspect to look at in terms of change. The ownership of risk, maybe it should be a shared risk, and maybe that's how we should look at it. Otherwise, the continuing debate of causation and foreseeability will continue. I suppose in simplest of forms, contracts must be worded as best as they possibly can to meet the specifications, the concerns, and the issues that each of the contractor or the employer has. You know, foreseeability within all jurisdictions of law is an intricate concept and has varying outcomes for both parties. But it need not always be ambiguous and unpredictable. An event which is foreseeable is foreseeable if a reasonable person can predict it. This is a relatively simple construct, yet the concept still complicates legal issues, and maybe we need to develop ourselves past that, because we are dealing with foreseeability of something which is very, very live and exists in the workplace at this point in time. So what should we do? Well, we should follow the basic principles and make the very best effort we can. You know, clearly state the parties involved at every stage of the project, make the rights and responsibilities of parties clear, determine the resolutions for the breach of contract, and maybe we'll see more amicable settlements. Perhaps we'll see more expert determinations. Perhaps we'll do away with the major arbitrations which almost take both parties into Armageddon, because there's no real conclusion and there's no real answer in some of these issues that we have until we develop the case law and we develop the law against it, and we allow experts to be able to make conclusions on whether the foreseeability was possible or not. And to that extent, the resolution of conflicts and disputes should be clearly annotated and dealt with properly. I'm not sure I can talk too much more to foreseeability and the damages and the costs that follow from that. We've had a tremendously difficult period of time with the coronavirus, and it has placed a new world order in respect of construction disputes, definitely from construction disputes in terms of the ownership of risk. And it's unfortunate that we've seen employers and contractors go into insolvency, and that's probably because somewhere along the lines the risk was owned probably by the person who couldn't deal with the risk in the best possible way. I think my final part of my talk today was just to talk to the mistakes that expert witnesses do make, and obviously how to avoid them and how they should be dealt with. I think, you know, the big issue for expert witnesses is the same with everybody. You know, one mistake can render your reputation terminable. And that is not the situation you want to be in. And you don't want to be advocating cases for your party. You want to be given an impartial opinion to the tribunal. So very, very difficult now in the foreseeability tests and causation, etc., not to put something forward which you actually genuinely believe in. I mean, you need to make the case correctly so that the arbitration panel and the counsel and advocates who work for you can submit their case on the best possible basis with regard to the specific law. Now, what we've always talked to in respect of experts, we've talked of experts who fail to amend their opinions when they've been provided new information. Well, we're going to see new information through this whole period. We're going to see how effects were and how developments were. And it's, you know, the lesson for experts now is not to conclude an opinion based on what you see at the moment, because you might see something in 12 months' time, which actually then again changes the approach that you think you ought to have taken in respect of that causation and the effects against it. Again, you know, the issue that I recognise in terms of expert work moving forward for my own practice talks very much to making sure that I do give an opinion in whether it's an adversarial or an inquisitorial process before arbitrators, not turning my testimony or my report into something which becomes a classroom lecture, because that's the easy way for me to deliver something that I'm not quite sure on. So, you know, I am recognising now that I must deliver something which is based on the facts and does provide an opinion, and it's based on my best interpretation of the facts that I can provide, and not turn it into prospective delay and retrospective delay and all these different methodologies and hope that the arbitration tribunal will decide on it, because I can't make my own mind up. Obviously, as we move forward, there's in arbitration tribunals, and if I was to be cross-examined by David, then I'm sure there's going to be situations whereby he does not agree with what I say, or he wants to question me further on it. And in that respect, morphing into areas where we're not always clear and not always sure, experts don't want to argue, and they don't want to put themselves in a position whereby they are becoming adversarial to the person who's questioning them. Similarly, you want to remain articulate, and you don't want to undermine your own credibility. If you do make concessions when put under pressure by the arbitration tribunal or by the counsel for the other party, then making concessions is not a bad thing. Being honest and clear about issues is correct. And if counsel makes the correct point in terms that, well, you need to consider this issue, you need to consider that issue, well, it's being flexible and it's being able to take that approach forward, because we're all going to find our way through this by learning and understanding off each other. Nobody has this one single answer at this point in time. The other issue that I've learned through expert work and working with other experts across the world, and I don't put myself in this category, are those experts who argue one opinion in a matter for the claimant, but then argue the opposite opinion in a matter for a respondent. And you know, those issues, if you're going to argue that COVID caused this, but in your next matter you argue that COVID didn't cause that, then you're not actually being impartial to the arbitration tribunal. You need to give some care and attention to that. Experts cannot drift outside their area of expertise. An astute cross-examiner will invariably run them out on a limb, and then no doubt they'll cut that limb off for the arbitration tribunal to see. So don't damage credibility by going into areas outside your expertise. Don't talk about issues of COVID which are not in your expertise. Your expertise relates to quantum and delay, and that's where you sit with it. And then finally, my final point is that a common mistake of some experts is to profess specific knowledge of an area of expertise. If you don't have the knowledge, you don't profess the knowledge, you don't put that before the arbitration tribunal, you stick to where you are, you stick to what you understand, and you explain it correctly. Because the COVID situation will continue. We will see the first phase can end, we will see the second phase, third phase, we'll see continuing phases for the next 4 or 5 years. This is a developing form of expertise as it is a developing form of law. And the only approach to it is to learn as we go, but to be honest and candid and be truthful to the instructions that you are given. Again, I think I'm concluded there. I'd like to thank the Foundation for inviting me to speak today. It's been enjoyable, and you know, it's been difficult to talk about topical issues in respect to the application directly to my own role as a delay and quantum expert. But I hope you've enjoyed listening to the presentation. I did enjoy listening to David before, and I'll hand you back to Shimanga now in case there are any further questions. Thank you very much.
Thank you so much, Mr. Damien. We do have a few questions in the Q&A box, so I'll just stick to a couple of them for the sake of brevity. We have a question from Mr. Jaraj Vinod Wilfer. How would time as essence of contract be approached under the COVID-19 scenario in a given dispute?
Well, maybe I should defer that one to David there, really, given the actual wording of time as essence of the contract. Maybe David, you want to take that one from me?
Thank you, Damien. I think time. Remember, time of the essence means that time has been made a condition of the contract, so that the contract can then be terminated if it's not performed in the period. So, time of the essence commonly comes from, for example, contracts where goods are to be delivered, and the starting point is that goods are to be delivered within a reasonable time. That's the same under a building contract. If a building contract doesn't specify time for delivery, the work is to be completed within a reasonable time. In building contracts, construction contracts, we have traditionally changed that, and we put in a fixed completion date. So time, it's not that time is of the essence, it is that there is a completion date. The remedy to that is an extension of time if delay is caused by the owner or by an outside event for which the owner carries the risk, which would include force majeure. So it's or the contractor pays liquidated damages if the contractor doesn't get an extension of time. And then if the delay goes on for long enough and there's no extension of time, then there's termination. And that's why my friend Paul Darling was in the Supreme Court in London last week, talking about the interrelationship between liquidated damages and termination of contracts. But anyway, I digress. So really the concept of time being of the essence is not relevant generally to building contracts, unless you've got a building contract where for some reason time is completely at large and somebody then seeks to make time of the essence. So I would avoid that as a distraction. It gets us down some very, very interesting rabbit holes. But fundamentally, a building contract, you have a date fixed for completion that is then varied or not with particular consequences or not.
Sure, thank you. We have, as the final question for today, again, can be answered by either of the panelists. From Mr. Armugam PK. Should there be an amendment to the contract so as to address delays due to the pandemic on the cost and timelines, or whether the force majeure clause takes care of that?
Well, I think I can answer first, and I expect David will have something to say in respect to the second part of the question. I think an amendment to the contract to address the delays due to the pandemic on costs and timelines would be of an equitable basis to both parties. How they would determine what period of time and what amount of costs is included in the amendment may be subject to a dispute, which may be subject to an arbitration. So as we talk to single joint experts and expert determination, that may be something that parties want to consider, but it doesn't necessarily mean that they will accept that decision unless they both agree to be bound by it in the future. So yes, I think the good guys and the bad guys, somewhere in the middle, there are amendments to contracts which deal with that. But obviously I touched on the point in respect to future contracts and future projects is almost identifying the time contingency and the risk contingency where an allocation has been made for a COVID effect. And if it's 20 days, but it needs to be 25 days, then perhaps the parties are then both bound by the change of the 20 days to the 25 days. And they are both bound by the P&Gs which relate to those extra 5 days. The problem with that is the uncertainty that arises. And because of that uncertainty, it tends to lend itself to the second part of the question, that the contract must prevail. And if it is force majeure, then there is time only, there is no money. And obviously from David's discussion that we had at the start of the day, then obviously force majeure lends itself to further disputes and further arbitration of disputes by tribunal members. And in the avoidance of disputes and the avoidance of dispute costs, the amendment would be perfect. but it lends itself to further disputes and further debates and discussions between the parties, I'm afraid.
Yeah, I think picking up really what Damien has said, distinguish between future contracts and past contracts. An event of force majeure as defined is always, remember, and this goes to much of what Damien was saying, something that is out of the control of either of the parties and is not foreseeable. So for future contracts, and indeed for contracts that are being entered into now, force majeure isn't going to be the answer, because arbitrators are going to be faced with people saying, well, hold on, disruption because of a pandemic was perfectly foreseeable, and one or other of us should have dealt with it because we just had COVID. So on future contracts, force majeure will not assist because it will be said that it was foreseeable. For contracts that exist at the moment, whether or not force majeure will assist, well, that will frankly depend on the wording of the contract and the particular arbitration. As Damien says, generally force majeure doesn't help contractors to the extent they want to be assisted, because it relieves them, it gives them an extension of time, so they're relieved of an obligation to pay liquidated damages, but they don't get loss and expense. So they don't get the money that they want and need. Equally, owners don't get the asset that they want. If you want a desalination plant and it's 6 months late, it's still 6 months late, and you've got 6 months without a desalination plant. So force majeure may help you answer those questions in existing contracts that have been disrupted this year. But frankly, if you ask me, and this is talking myself and Damien and others on this call out of a job, but if you ask me if people are going to be better off reaching some sort of accommodation to deal with each other's cash flow, delivery of assets and stages, or will be better off resorting to the contract and an arbitration, parties are almost certainly, especially given the uncertainties of COVID, and the factual uncertainties that arise, will be better off negotiating some sort of deal finally to get the asset built and delivered.
Sure, sir. Thank you. Thank you so much. So I expect Mr. Anishwarya would like to give a quick comment.
Yes, I mean, thank you, David and Damien. A quick supplement to what Damien said moments ago, and I think it's important to drive that point home, is today when you're acting as an expert, particularly in the Asian context, I appreciate and I understand the temptation when you get expert appointments, particularly in high-value construction disputes. The natural tendency is to lean towards what the party appointing you is seeking to prove and justify. However, like Damien said, that is an absolute dead no, and I'm driving this point home based on some recent examples that I have faced in an arbitration where we're acting as an arbitrator, where I just happened to be the same arbitrator in two different tribunals, one where I was presiding, the other co-arbitrator, and precisely the point that Damien mentioned, I had an expert who said one thing in one arbitration, stark opposite in the second arbitration. And he made a mock of things. And counsel like, David, Chantel, in these arbitrations, and this is what they will do during cross-examination, is tear this testimony apart. And many experts may think, hang on, how would the counsel know what has happened in here? Because they may not be the same counsel. Please understand and remember this. All sophisticated firms, sophisticated counsel, always do their homework on the expert. When you submit your CV, it's, people talk about the expert, what their views have been. So don't think you can hide away in the garb of anonymity. It's very likely that they will know what you've said in one case or the other. So just please keep that in mind, that both from the perspective of an arbitrator, your legitimacy, if you want to be taken seriously before an arbitrator, and if you don't want to face intense cross-examination from David and Chantel, please make sure you are consistent, because it just takes one flash of a second to ruin your entire career and reputation if you're known to flip-flop between whoever appoints you. You lose legitimacy. Thank you.
Thank you, sir. And thank you, Mr. Damien, and thank you, Mr. Dave. It was quite an enlightening session, and I hope the attendees feel the same. So before we conclude this webinar, for the attendees specifically, I've sent the feedback form in the Zoom chat box. And for those who have joined us on Facebook, I've put it in the comments section as well. So it's my humble request that you fill in the feedback forms for today so that we can confirm your participation for the sessions for today. And I'll be doing so for the same in the same manner tomorrow and day after tomorrow as well. So we have tomorrow we have the session again from 5 p.m. IST till 6:30, and again day after tomorrow the same. Tomorrow we have Miss Chantal Humphrey joining us, and we have Joanne Byers joining us day after tomorrow. So I hope everyone had a good session along with us today. See you tomorrow.
Thank you.
Thank you.
Thank you.
Thank you very much.
Thank you, Damien and David.
Thanks, Inba.